Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. Thank you to everybody who got up with Washington Gun Law this morning and sat around while we went through the orders list, only to find out that the thing that we were most anxiously awaiting wasn't happening again. Obviously, those cases are going to be relisted for a new conference date, but I know a lot of you are really frustrated and you're thinking that there's absolutely nothing going on at the Supreme Court at all when it comes to your Second Amendment rights. Au contraire, actually there is quite a bit of activity, and we're going to try to break it down for you here in a few short minutes so you can understand everything that's going on. So today, let's spend a few minutes and let's talk about an update on all Second Amendment Supreme Court cases. Okay, America, this is what we're talking about today. We got up early this morning, like we do almost every Monday, it seems like, and we were waiting for word on Snow v. Brown and Ocean State Tactical. We didn't get any word, which means it is now being relisted for yet another conference. And that had a lot of people in the comment section during the live feed pretty frustrated, and I get where the frustration is coming from. I really do. And they believe that the Supreme Court is not doing anything when it comes to our Second Amendment rights. And I'm not here to suggest that they're out there viciously defending them, because that would be a comical video to try to pull that off. What I am saying is there's a lot more activity going on with the Second Amendment than you may be aware of. And so what I want to do today is I want to break down all of that for you. We want to do it kind of in rapid fire fashion so that you can understand what's going on. Now, one of the things that happens at a conference can be that a petition can be accepted, or it can be denied. And sometimes a denial is exactly what you want. Let's first start with a case today that was denied. That's the case of Worth v. Jacobson. Some of you may know it as Worth v. Harrington. It comes out of the 8th Circuit. Now listen here, this is important. This was a successful challenge to Minnesota's ban on allowing 18, 19, and 20-year-olds to carry firearms. This case has been successfully litigated at every level, including a 3-judge panel before the 8th Circuit. An en banc panel of the 8th Circuit declined to review it, and they petitioned to the United States Supreme Court, who in relatively short order has denied that petition. Now, I'm going to go back and read just a small portion of what the 8th Circuit 3-judge panel ruled because, well, in the 8th Circuit, this is the law of the land. And this will be a case from which you will see many other arguments develop nationwide. So everyone needs to pay attention to this. Minnesota's permit to carry statute, among its objective criteria, requires applicants to be at least 21 years old. 3 gun organizations, through their members, challenged this age restriction for violating the 2nd and 14th Amendment to the United States Constitution. The district court granted summary judgment to the plaintiffs, finding the Second Amendment's plain text covered their conduct and that the government did not meet its burden to demonstrate that restricting 18 to 20-year-olds' right to bear handguns in public was consistent with this nation's historical tradition of firearm regulations. Minnesota appeals, having jurisdiction under 28 U.S.C. Section 1291, this court affirms. So understand that the 8th Circuit panel had found that there was no historical analog to support this ban and that it lacked any type of constitutional validity. The panel ruled Minnesota has not met its burden to proffer sufficient evidence to rebut the presumption that 18 to 20-year-olds seeking to carry handguns in public for self-defense are protected by the right to keep and bear arms. The carry ban, section 624.714, subsections 2B2, violates the Second Amendment as applied to Minnesota through the 14th and thus is unconstitutional. So as I mentioned, the denial by the United States Supreme Court of review on that matter is huge, okay? And so we're going to have to very carefully watch that case. That again is Worth v. Jacobson or Harrington, however it's being listed. Now, there was another case that was denied today, not a huge surprise. It's the case of Srour v. New York City. We have talked about this before. This was a challenge to New York City's good moral character and good cause and things like that. What had happened in the interim, though, is Srour had been granted a license. New York City had done that to moot the case. Srour still wanted to appeal. The Supreme Court took no interest in taking up a case in which they believed the issue had already been mooted, so that petition has been denied as well. Now, let's remember, we're also still waiting for a ruling and this is big. This is going to be really big in Smith & Wesson v. Mexico. That ruling we're probably at least another month out from getting, maybe 2 months, but that is going to be a massive, massive issue of which there is a whole house of cards and dominoes lined up on other lawsuits against gun manufacturers that could crumble depending on how that ruling comes down. Now, we know that Snopes v. Brown and Ocean State Tactical cases did not get any thumbs up or thumbs down today, and so they're going to be relisted yet for another conference. I want to get you up to date, though, on all of the other pending petitions before the United States Supreme Court in rapid-fire fashion, because I want you to understand there's a lot of activity going on here. Woodson v. Florida. It's a challenge to Florida's law that bans possession of firearms by those that were convicted of nonviolent felonies, and it is already scheduled for a conference now on May 2nd. Trevino versus the United States. This is a challenge to 18 United States Code Section 922 G1, which prohibits felons from possessing a firearm. This is also now scheduled for a conference on May 2nd. B&L Productions v. Newsom. This is a First and Second Amendment challenge to California's law, which basically bans gun shows, okay? And this is actually scheduled for its first conference on April 25th. Wheeler versus the United States. This is a facial challenge to 18 United States Code Section 922 G1. Good luck with that. The briefs are due on May 2nd. I do anticipate that this one could get denied petition, and even if it was granted, I don't see how you win a facial challenge to that. Wolford v. Lopez. This is one of Hawaii's crazy laws where you cannot carry any firearm on private property without express permission of the property owner. That is before the United States Supreme Court, and Hawaii's response brief to the petition is due June 4th. Turner versus the United States. This is a quasi-challenge again to 18 United States Code 922 G1, but this involves whether or not we should resolve a constitutional challenge to a firearm charge before the individual actually gets sentenced on the firearm charge. The United States brief is due on that case May 16th. Smith versus the United States. This is a challenge to 18 United States Code Section 922 G3. This is a prohibition on people who possess firearms that use illegal substances. The United States brief is due on May 7th. That's got GVR written all over it based upon Rahimi, a la Range, and Daniels. Faust versus the United States is both a facial and an as-applied challenge to 18 United States Code Section 922 G1. The government's brief is due April 30th. Now, on a side note, I think the likelihood of prevailing on a facial challenge to 18 United States Code 922 G1 is next to impossible, if not completely impossible. An as-applied challenge, however, could be successful, but again, if the court believes that there is a potential for an as-applied challenge, it's getting GVR'd based on Rahimi. Oh, and by the way, I'm not going to bore you with this, but there are 20 other filed petitions right now challenging the constitutionality of 18 United States Code Section 922 G1. Obviously, that's got a whole lot of GVRs written all over it, but it is very obvious that this is an issue that is not resolving anytime soon, and the Supreme Court at some point is going to have to weigh in on this. Williams versus the United States. This is a Second Amendment challenge to 922 G1, but it also has a Commerce Clause challenge, which makes a very, very interesting angle. Kudos to the attorneys who came up with it. I do like creativity. The government's brief on that case is due April 30th. Stump versus the United States. Now, this has a really fascinating potential to it. It's a 2A challenge to the ban on possessing firearms with obliterated serial numbers. But one of the issues that to be decided is that can certain weapons just automatically be excluded from Bruin's first part of the analysis? That is, that there are certain arms that are not even covered by the Second Amendment. It's a fascinating issue and one that we've seen courts, Seventh Circuit, for example, wiggle their way out of on assault weapon bans, magazine bans, and such. Hansen versus District of Columbia. That is a challenge to the District of Columbia's magazine ban again. The district's brief on that case is due April 30th. And then finally, Perez Garcia versus the United States. Now, this is an as-applied Second Amendment challenge to the laws which require people to disarm themselves as part of pretrial conditions of release. So it has a bit of a Rahimi angle to that as well. Again, it's got GVR written all over it, but right now there is a petition pending before the United States Supreme Court. Okay, so that's everything that's going on in the United States Supreme Court related to your Second Amendment rights currently. Again, the big news today is the fact that the Worth v. Jacobson case was denied certiorari, which means the ruling of the 8th Circuit stands. Congratulations to the folks over at the Second Amendment Foundation. They led the charge on this case, which means we got a link down below for all of you to show them some love. If you guys got any other questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington gun law by now. But if you don't, that's okay. That information is down there in the description box. If you got an idea for a video we should be doing around here, cool. Just click on that link right there and tell us all about it. If you want to subscribe to our monthly newsletter, the ability to do that is down there in the description box. And then finally, and most importantly, America, let's remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching. Stay safe. So today we want to check out and see how secure StopBox really is. So we're heading over to one of the book clubs to have it tested by one of the most dangerous creatures known to man. That's right. I'm talking about the drunk suburban housewife.
You guys, your name's it's Mud.
Oh, hey, ladies.
Oh, hey!
How's book club going?
Oh yeah, I have a shit ton of stuff.
You look like a Lolita.
No.
Lolita.
What is wrong with me?
Call me Steve, Jake. Ew. You look like a Hannah.
Taylor. No.
Yes.
No.
Yeah, with those lips, you're
100%
Lolita. Spicy.
Yeah.
Cumin.
Sorry.
Okay, ladies, got a little challenge for you here.
Oh.
Yeah. Okay, so listen, here's what I got. I got a $200 spa package to Willow's Lodge.
Ooh la la.
I got 2 days, 2 nights at Suncadia. $100 at Target.
Nice.
And $100 at Wine and More, because I know you can need that. So, any of you get into the box, it's yours. Have fun.
Okay, who wants to go first?
I can get in
Okay,
the box.
Beth. Get it, girl. Get it, girl. Come on.
Get that spa package. Oh! Yeah.
Come on. Ooh. Get it. Come on.
You gotta push all the buttons. You're doing the same thing over.
Come on.
You have to figure this out.
I just give up. I'm pouring more wine.
Give up?
Yeah, I give up.
All right, well,
You didn't pour me any.
close, but looks like they're all mine. Thank you, ladies.
What?
StopBox. Protect your family while protecting your family.